circulation and publication on the YouTube channel.
Why don't we first see the order?
I am just referring to why this case.
Yes.
This in the said YouTube channel, there is a video which has been published and circulated, which is very derogatory and malicious and tarnishing the Honorable Chief Justice of India. There was a video. In that scope, F.I.R. has been lost. Now, kindly see the first. I will take up the what is the contents of the F.I.R. Then the court bill is ordered. The MAT application, can 1 Can 1 at page 15. Can 1.
Yes.
Kindly see the F.I.R. is on 13/9/2024. Kindly mark the date, kindly. Then the sections are 267, 352, 353, 1B, C, subclause 2 of the BNS. I will read later on what is the corresponding section of the I. For the moment, I am not. Next page, 16.
No,
16, 16.
That is of Can 1. Lordship. Lordship, am I audible, Lordship?
Can
yes, you are. Only thing is that, may I intervene for a moment? Lordship, may kindly see the order once. I will. Of course. Advise you, Lordship. Yes, sir.
Yes, sir. I such and such. Lordship, what is just I such and such may not be then address. This written complaint against a reporter anchor named Sudhushil of Priyobandhu Bangla Media uploaded and circulated an offensive video against the Honorable Chief Justice of India in pertinence to the matter of R.G.Kar, which the Supreme Court took sumoto cognizance of the matter. The reporter anchor has mentioned above prepared a report and circulated the contents through communicable devices that are very much offensive, defamatory, and menacing in character. The manner in which the reporter addressed the Honorable Chief Justice of India is very disrespectful, and the full content of the said news report circulated by the reporter is false and caused annoyance, inconvenience, insult, injury, and criminal intimidation. Whereas the reporter anchor intentionally made the false report by distorting the original fact and misrepresenting the false information to create enmity and hatred toward the society. Not only that, the media with malafide intention circulated the news report challenging the power of the Honorable Chief Justice and also in imaginary way threatened the public to agitate against the Honorable Chief CJI solely. That the said circulation report where the reporter anchor alleged that the Honorable Chief Justice of India is not performing his constitutional obligations by delaying the process of justice to the public of nation. It was also alleged by the reporter that the Honorable Chief Justice is working as per his own hidden agenda and the CJI is intentionally lingering some cases, legal issues according to his own sweet will without considering the gravity of the cases and law of the land. But the reporter even alleged that CJI is acting biasly in some selective issues, thus by circulating the said video, the anchor intentionally, next page below, insulted the CJI of the country and the entire judicial system of the nation by provoking the public at large, which shall break the public peace and tranquility and create a feeling of hatred, enmity and doubt among the minds of the people of this nation. That the reporter anchor had stated in the report that the Honorable Chief Justice of India is the most tarnished CJI ever in our judicial history, and the Honorable Chief Justice shall immediately be impeached from the chair. That the reporter also stated that the hearing of the matter R.G.Kar will not be listed before the Honorable Supreme Court and R.G.Kar will not get justice until the Honorable Chief Justice is impeached from the acting CJI. That the entire report news is fake, which was circulated on social media to intentionally defend the Honorable, which was the content that was published in his own the YouTube channel. It has been circulated. There are lakhs and millions of people of the viewers. This video has been circulated on 2nd September. R.G.Kar incident took place on 13th August 2024. 9th August. 13th August. What is it? 2nd September, this video has been circulated, uploaded. 13th September, this F.I.R has been lost. Just after 10-11 days. After how many days? This F.I.R was 10-11 days. 10-11 days. Yes. 13th September, this F.I.R has been lost. Yes. 2nd September, this uploaded. That is published. Yes. And kindly recall, my lord, in entire state, even across the country, even there was my lord, anarchy with regards to this Arjikot situation. Admitted. Now, my lord, Now, my lord, kindly now come to the sections. My lord, it is troubling me and why I am agreed by. This is the reason I am coming. I am telling cut shorting the matter. My lord. 267, 352, Venus. 267, 352, 353, surplus 1, B, C, 2. My lord, এসিটা কিন্তু বন্ধ করা যাবে, এসিটা একটা মিনিট লাগছে বা টুইংসটা কিন্তু উপরে তুলে দেওয়া যায়। Yes, yes, Milord. Section is 267, 352, 353, 1BC2. Milord, first I will read 352. 267 I will come later. 252. 352, Milord. 352. Milord. Milord. I hand over my book, Milord. Yes, I think so. But it is marked, Milord. Kindly be excused, Milord. 352 power check. 47 आपकी इग्विटी टूल तभी फ्लोरेंटली रैप उनके पहले और तो बाद में अपनी 53 चल जाए also the matter lordship can be cut short. An argument could be advanced by citing the order itself, why the order was stayed, why the F.I.R was stayed. No, 151. Yes. Lordship got. Does that? We are not well once we diffuse the amendment. It will take some time. Yes, even it's to some extent difficult. 352 Milord. Lordship got it. Yes. Now intentional insult with intent to provoke breach of peace. That was the Milord the heading. Whoever intentionally insults in any manner and thereby gives provocation to any person, intending or knowing it to be likely that such provocation will cause him to break the public peace or to commit any other offense shall be punished with such and such. May I very candid? This is a non-cognizable and then non-billable. 350. Non-billable. Non-billable, non-cognizable. Now 353. 353 Milord, these sections which has been added, 353 surplus 1, B, C and 2. This has been section added. Now 353 can come. Statements conducting to public mischief. 1. Whoever makes, publishes or circulates any statement, false information, rumor or report, including through electronic means. So 353 surplus 1 Milord will attracted. Milord, then B and C. Next page. With intent to cause or which is likely to cause fear or alarm to the public or to any section of the public whereby any person may be induced to commit an offense against the state or against the public tranquility. And similar, with intent to incite or which is likely to incite any class or community of persons to commit any offense against any other class or community. This section means non-billable and also means cognizable. Cognizable. And 354 3 subclause 2, whoever makes, publishes and circulates any statement or report containing false information, rumor or alarming news, including through electronic means, with intent to create or promote, or which is likely to create or promote on grounds of religion, race, place of birth, residence, language, custom, community, or any other ground whatsoever, feelings of enmity, hatred, or ill will between different religions, this is also, my lord, the non-bailable and cognizable. Now, my lord, kindly examine the 267 section. Lordship got it? Yes. 267 is, my lord, intentional insult or interpretation to public servant sitting in judicial proceeding. Whoever intentionally offers any insult, causes interruption to any public servant, while such public servant is sitting in any stage of a judicial proceeding, shall be punished with simple imprisonment for a term which may extend to such and such, my lord. This is also, my lord, non-cognizable and bailable offence. So, my lord, here, out of the 3 sections, 2 are non-bailable, 2 are cognizable, 1 is non-cognizable offence. My lord, in section, which is, my lord, TRPC, in BNS 174 section said, BNS 174 subclause 4 says, where a case, what I am reading, and where a case relates to 2 or more offences of which at least 1 is cognizable, at least 1, the case shall be deemed to be a cognizable case, notwithstanding that the other offences are non-cognizable. So, my lord, here, the F.I.R. of 13/9/2024 discloses the cognizable offences. Discloses the cognizable offence. The moment on 13th September they disclosed the cognizable offence, police had registered this F.I.R. under these sections. Because, Lord, it is the duty of the police, it is the law of the land, the moment the cognizable cases has been disclosed, immediately has to be registered. An investigation to be carried out in terms of the procedure. So police had done this, and then in consequence they had to, my lord, issued a notice for his appearance to substantiate and to produce some documents. That notice was issued, my lord, on 16/9/2021. I have annexed page 18. My lord, must be, yes, right, your lord, yes.
This is 13/9.
13/9, asking him to appear on 16/9. That is, your lordship will find 1, 2, 3, 4, 5, 6 line. You are directed to appear.
Yes.
That's why I said, because I am skipping, my lord, that 16/9. But in the reply to a mail, he said that I need a more time, and then he sought for a time.
Anyway, documents were sought for from this person.
Exactly. These are the documents did you A, B, C, D, F.
A, B? No, not A.
You will not commit any offence in...
No, which document?
It's a completely wrong statement made.
How many documents?
35 2 notice was issued.
How many documents did you see?
Malad, I am coming. 16.
Lordship, 35 notice was issued.
Malad, I am coming.
I expect the submission.
Please don't interrupt me in this way. This is not the way to...
But that is not the way to misguide the bench. Please say that 35 2 notice was issued.
Mr. Chatterjee, we will not decide this case ex parte. If we at all decide, we will hear you.
My lord,
You point out whatever erroneous submission is made on behalf of the appellant. As it is very difficult to hear you virtually. You are not very clear. The sound quality is not very good. Please don't interrupt. We'll hear you. If we decide the case, obviously we'll hear you. Now you see, here it is that we produce all relevant documents
for the purpose of investigation. It is for the purpose of, my lord, investigation, my lord.
So
these are the direction were given, police.
Definitely, but actually you see,
some specific document? It was not, my lord, because kindly see on 13th we received and then 13th the notice was issued. That's why we will examine, we will carry out the investigation. Yes, this is the reason. The person will appear. Exactly, my lord. You will also comply with everything you will do. This is not a case, my lord. This is not my documents. Case. Yes, so notice was issued to him, and then definitely he has sought for a time. Then, my lord, on 20th 9/2024, my lord, he has filed this petition before court. On 7th, challenging this notice. Challenging the notice. F.I.R. And F.I.R. For quashing. Read file for quashing of the F.I.R. and challenging the notice on 17th instead of the next day. And the learned judge has quashed it. Not quashed it. Interim. What is the interim order? Yes. Now, my lord, kindly come to the order. Impugned. My lord, first, before I come to the impugned order, I would like to hand over the in between the order passed by the learned judge, my lord, both below. Lord, may I hand over the two orders? My lord, sorry. My lord, kindly turn out the second my lord, page. That is the order which I have handed now just now. The order dated 25th September 2024, my lord. Yes. 20th September, my lord, second running page. The very first day, my lord, the police are restrained. Lordship got it, the last from bottom. Page 25/9, that is 25/9. No, my lord. Order dated 25/9. Yes. Second page. Internal page 2. Page 2. Second last paragraph. Page number, lordship. The police are restrained from taking any step in respect of subject. Which page you are referring to? F.I.R. till 4th October 2024 until further order, whichever is earlier. So, my lord, in the 25th September, so F.I.R. was registered 13th September, notice issued on 13th September, asking him to appear on 16th, 17th he filed a repetition, 25th there is an order of prohibitory order from the learned court, my lord. Now, my lord, what is the order into? Mat, it has been annexed. Lord, I will skip straight away. I'll come to page 3, running page 3, Lord, of the order annexed in the mat. Lord, Justice Chaudhary, I think page. Lord, the order. This is the impugned order. Yes, Lord, impugned order. So certified copy must be here. Yes, this is the running page 3. Mat. It has been annexed to the mat, Lord. Yes, running page 3. Page 3, paragraph 10 of the said orders, Lord. Paragraph 10, yes. As regards the complaint filed by Otri Sharma, it appears that the entire allegation revolves around the judicial proceeding suo motu taken up by the Honorable Supreme Court in connection with a brutal incident which took place in the Arjikar hospital. Several mass protests and agitations are taking place in the state, country, and even beyond the boundaries of the country from the very next day of the incident. There are various versions of the incident that are doing the rounds. The manner in which the general public has got themselves involved in the mass agitations reflects the views of the public in general and not of an independent individual. Then, my lord, 12. I am skipping paragraph 11, 12. The court has conversed with the de facto complainant, Otri Sharma, who was present virtually. My lord, in the earlier order, he is directed to appear virtually or personally. He disclosed himself to be the legal practitioner and submitted that he was concerned with regard to maintaining the dignity and majesty of the judiciary. Then, my lord, kindly come paragraph 14. The court is not at all convinced how court has arrived. There was no case diary even called for, no daily diary even was produced, nothing, but court said convinced that there is any likelihood to cause fear or alarm to the public or to any section of the public to commit an offence against the state or against the public tranquility by the act of the petitioner. The right to free speech ought not to be curtailed by putting threat on individual to initiate criminal proceeding. According to the learned judge, F.I.R. lodging is a threat. 15. The instruction forwarded by the inspector in charge Siliguri police station, it has been instruction to me, Mila. in connection with a case number such and such, does not mention whether the public or any section of the public committed or tried to commit any offense in furtherance to the video which was uploaded by the petitioner. Because that would be reflected in the CD. Case diary, it is a mirror. It was the instruction from the police station, the police personnel, that this is the progress of the investigation, which I have handed over to the learned judge. Now, paragraph 16. As regards the allegation of airing offensive, defamatory and menacing report against the Honorable Chief Justice of India, the police could not have taken steps in response to such allegation till there is any complaint lodged by either by the Honorable Chief Justice of India upon instruction of the Honorable Chief Justice of India. With regards to our 267, that is the Honorable Chief Justice of India, if he is being aggrieved, then he can file. But here the section, even in the Honorable Supreme Court, even in other the false and the malicious the video uploaded in the same issues, the cases has been initiated by the Honorable Supreme Court even at the instance of the Honorable Chief Justice of India. So 267, the person being aggrieved, the Honorable Chief Justice, definitely. But section with regards to the 353 subclause 2, 353 is B.
So what is there 353?
Which I have read.
That is the cognizable and non-bailable.
Cognizable, non-bailable.
353.
353.
Yes, 353. 2. No, 3.
353. 353B.
353B.
1B. 1B.
So that is cognizable and non-bailable.
Yes.
No, here you see this is an admitted position. There is derogatory remarks upon the Chief Justice, interference in the administration of justice. Definitely, on the face of it is appears. But how far this section is applicable? That is the only question.
353.
Yes.
That is the police to investigate.
No. How
that police will, that is the court cannot sitting over the
from that allegations.
Can you read again? I am reading
that section. Undoubtedly, it's a derogatory remark.
B. Can you read B? With intent to cause or which is likely to cause fear or alarm to the public or to any section of the public. So, my lord, by of this circulation, that is a cause of fear or alarm to the public, whereby any person may be induced commit an offence against the state or against the public tranquility. Number 2. C. With intent to incite or which is likely to incite any class or community or person commit an offence against any other class or community is a provocative. 2. Whoever makes, publishes, circulates any statement, report containing false rumor or alarming news through electronic media. So remember, this is the reason 353 subclause 2 is well attractive.
Where is the other section which you relied?
267 1.
267.
That is upon the person being aggrieved, the Honorable Chief Justice. There are 2-3 sections has been incorporated.
Yes.
One is cognizable, 2 is cognizable, 1 is non-cognizable. I say from this section that if the one section is a cognizable offence, then other would be deemed to be a cognizable. So, when the cognizable offence has been disclosed, it is the duty incumbent of the police to carry out the investigation. May I read further sections? So now come to the judgment, my lord Justice. No, my lord. I read 16, my lord. Now, my lord, 80. Though the court is not appropriate authority to advise as to how the police should deal with such complaints, but the court feels that the police have far more important issue to handle rather than spend time on complaints which do not disclose any proper offence and are more to gain public attraction. Because whether the offence has been disclosed or not, prima facie it has to be seen. The moment it is the prima facie has to be seen, police shall carry out the investigation. After causing an investigation, if it's find the genuinity complaint, end it with the charge sheet or end it with the FIR, whatever. That is the prerogative of the police fellow with regards to carry out the investigation. 90. The court is not inclined to permit the police to proceed any further with the FIR that had been registered in response to the complaint filed by Otri Sharma. Here I am agreed. Next I am agreed, very peculiar, my lord. The respondents are directed to file an affidavit disclosing the necessity to proceed with such complaint in a mechanical manner without proper application of fine. Date is 22nd/11/2024. So, my lord, in one hand, investigation has been stopped after 10 days, my lord. No investigation could progress. By an order of this honorable court, my lord, say police cannot proceed with the investigation. In the other way, I have to file an affidavit disclosing the necessity, how I will. Because now in the meantime, what police have done within the 7 days, but he has seized the pen drive which the complaint has through a pen drive which has been supplied to the authority. First he has made a seizure. Then, my lord, he has done. May I hand over the what he has done in subsequent to that? Just 2 things. Because a very short period, my lord. Very short period. Within that period, what police has done? The cybercrime was 1, 2, 3, 4, 5, 6, 7, 8. First is seized. Also got is seized 1. Column number 1. 1, 2, 3, 4, 5, 7, 8, 9th line. 9th line. First page number. Yes. 9th line seized. Roman 1. One pen drive containing video footage of YouTube post by such and such person.
You seized from whom?
From the complainant. Then 2 seized. Then what? Subsequently, what he has done? Cybercrime PS, Siliguri Police Commissionerate, for supplying the details of social media site YouTube. That is the YouTube portal's code. Then why Matigara PS number such and such? In response, Inspector in charge Cybercrime PS sent a mail to the administrator YouTube LLC 901 Cherry such and such requesting the authority to provide the YouTube account details having URL number, file office memo number dated 14/9/2024. Till then, my lord, this has been carried out. Thereafter, because of the matter is in season before the honorable court, my lord, thereafter we could not progress further, my lord. In the meantime, now, my lord, there is an embargo that police cannot proceed with the investigation. I am agreed by 1. Number 2, if I cannot proceed with the investigation, how I will file the affidavit disclosing what actually happened is, my lord, Justice Chaudhary's query, whether the section of 353 is being attracted or not. Then with this, my lord, whether this genuinity of the social media, the contents of the YouTube contents which has been uploaded. So, my lord, now, Lord, because I am constant of time, Lord, straight away I will refer a judgment, my lord. That is a 2021-19 Supreme Court 401. Before that.